Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay. How is everybody? Can everybody hear me? I think so, right? All right. Going to talk about ARCCA, the whole history of the ARCCA witnesses today. Had to go way back for this. Hello, Amy Celeste. Hello, Tater Bug. And Murder by Maestro, holding down the fort. Thank you so much for being my moderators. Hello, Aureus, Dark Side, Rosewater, Just Us Chickens. Hello, Betty Clark. Okay. Please hit the Please hit the thumbs up on your way in. Let people know that we're around and kicking. Hi, Vicky. Hi, Jennifer Ray. Hello, Confused. So I wanted to go through the history of the ARCCA witnesses as we go into Andrew Rentschler, who's the other ARCCA witness. Didn't give quite as extensive testimony, but can he clean it up for Karen Reed tomorrow? What was a disastrous Friday where Daniel Wolfe for the ARCCA accident reconstructionists showed videos of a crash test dummy getting hit by the same make and model of Karen Reed's car, smashing her taillight and injuring the dummy in very similar ways to the Commonwealth's theory. So now the jury has an image in their mind of how these injuries could have happened. And this was the refrain we've heard over and over from the Karen readers, the free Karen readers. You can't break a taillight with an arm. I think your own witness just proved that correct, that you can. We all knew you could. Not even going the same speed, going 17 miles an hour. There was extensive damage to the taillight. How did he get holes in this shirt that had to be from a dog? Well, guess what? The crash test dummy who was dressed up in similar clothes to John O'Keefe, strangely, after mocking this Commonwealth's witness who did his experiments in similar clothes to John O'Keefe. They dressed up, their own witnesses dressed up their dummy in John O'Keefe's clothes and got Same kind of holes on the arm, his arm. And looks like all these wounds could be possible. So now it's, now someone, free Karen reader left me a message. No frostbite. No frostbite. That's the reason. No frostbite. Have you ever heard of an igloo? Have you ever heard about the insulating powers of snow? Right? I mean, even though they did these experiments, ARCCA did, meaning Karen's own witnesses, with the wrong weight dummy, they still, and dissimilar speeds, they still prove the state's theory. So that why they showed that, we'll have no idea. I talked about the leaks that are coming out from Karen Reed's defense team, that Karen Reed insisted on showing those videos, that is what people wanted to see. She argued her lawyers, begged her not to show those videos. She showed them instead. She's clearly running her defense, something I've been saying all along, from going to the sidebars to picking out which lawyer is going to cross-examine the witnesses. She is calling the shots. And it may not be always the most best choice for her. And this is why many people are saying she may testify. Last time she'd leave it up to her lawyers. She sat down at the sidebars. This time she's running the show. So she may testify in her own defense. She may be the last surprised witness. Certainly, we've had memes about the ARCCA witness, Daniel Wolfe, have already started. Let me see if I can show you at least one. Here's one. Hold on 1 second. Please hold while I show you one. So this is Randy, the why don't you take 5, buddy? So Randy, the crash test dummy, is telling Hank Brennan to take 5. Well, he's got it from here. He'll prove the case. Funny. So I don't think anyone thought that was a good idea. Also, hey, Rockstar 60. 1 second. Roberta, love your channel here and on Patreon. Thanks so much for being a Patreon supporter. Always a great way to support the channel. Thanks for your hard work and fight for the truth. You're welcome. You bring me joy. I'm so glad I do. Thanks so much. Thanks for being here. So also, let me see if I can pull this up before. Yeah, here we go. Also, here's another lawyer's opinion. Matt Tepanek, also defense lawyer. What is happening? ARCCA's own reconstructionist seems to be corroborating the near destruction of the taillight at 17 miles an hour. Alan Jackson hasn't even completed his direct examination, and ARCCA appears to be a strong witness for the Commonwealth. Absolute insanity. I showed a witness saying, I showed a lawyer witness, a lawyer. I've been commenting on the trial too long. A lawyer, note my objection, showed her TikTok talking about the same thing yesterday. So let's get into the history of ARCCA. So hiding discovery has been a strategy for the defense team. So I want to go back to before the first voir dires of Marie Russell and the ARCCA witnesses, where Alan Jackson comes in. This is the day of the voir dire, and he argues that we should not be having this voir dire because it's so unfair to the defense, and the Commonwealth has hid discovery too. You'll hear Adam Lally's very sober and stunning answer to this. Take a listen. So here we are with the first voir dire. Let me see. I hope I queued this up right. Oh, wait, let me go back. I'm sorry. Sorry.
Are all of the witnesses here, Mr. Jackson?
They are, Your Honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
Your Honor, I'm so sorry. I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Russell. Dr. Russell, yes. The order I would propose based on scheduling, Dr. Russell, Dr. Wolfe, Dr.
So after not giving any information, so what is discovery? Discovery is any information related to your clients, communication with them, billing, anything related to them. Just like the Commonwealth, their reports. In this trial, Dr. Russell didn't write a report. Has to be handed over. And then you put in a certification of completion. I'm not sure if that's exactly what it's called, something to that effect. And you're done. The defense never handed over their discovery with a significant discovery with the ARCCA witnesses, and their argument was that we couldn't. We're putting up 3 witnesses, David Yannetti argued, that we've never talked to before because we can't talk to them because of the federal investigation. So here's Alan Jackson right before the voir dire of Dr. Russell saying he objects to it. How dare the state get 2 bites at the apple, etc. They're doing it too. Take a listen. It's a real childish temper tantrum.
Okay, then that's good because that's the order I prefer. So, all right. Do you have a CV for her? Good morning. Morning, Tori. Do you have a CV I could look at for her, please?
Let me see if I put it in my notebook.
It's up on the internet. Hold on, let me get rid of these.
Yes, I do.
And she has not written a report?
She's not.
All right. All right, let's bring her in, please.
Your Honor, before we get started, can I get an understanding? We started to say that at sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems a little unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolfe and Dr. Wrench?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
That's correct. Turned out that's a total lie. Total lie. He was emailing back and forth with them.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions, her full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense everything that the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
Well, we didn't, Your Honor, in fairness, They didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the stand.
1 week from the filing of the certificate of compliance.
Well, I don't know when this, I can't remember. My co-counsel indicates it was the day before trial.
Okay.
So during the course of, the trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to and did give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We'd been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, I'm not, that's not my, and I think the court understands, that's not my point. My point is not, I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is,
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about.
Your Honor, a stitch in time save 9. Your Honor, how many little idioms can I throw in here? How is it good for you if you don't ask specific questions about what she's going to testify to? How is that good for the gander? I'd like to know. What's good for the goose is good for the gander. I mean, come on. Come on. And just so obnoxious. I've done the damage that needs to be done for Jen McCabe. I mean, that's just directly to hype up the Free Karen readers, isn't it? That's like right to the Free Karen readers.
Never met, never heard of. Within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert. And if she testifies, cross-examine her again after consulting with our expert. That's 2 bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and you know, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
Your Honor, I said I said this at sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Marie Russell 3 days after I learned about her, which was the 17th of May. I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined that she would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? You had 1 week from when?
The day before the trial. So it would have been, I believe, April 15th. So what we knew as of that day, you were required to turn over.
All right, I need to take a quick listen.
What? All right.
Of course, she's got a. But I mean, how ridiculous! They got one report in the middle of trial, just her CV. They have no idea.
She doesn't testify.
Oh, wait. Hold on. Sorry.
Obligation. Commonwealth's motion, the Commonwealth's renewed motion.
So she's back with her decision. But he fought this every step of the way, is my point here.
Never mind, Jim.
Paper 360.
I've got it, yeah. All right, so the Commonwealth has moved that I exclude the testimony of Dr. Russell based on a violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14. And I'm quoting from the notes, the importance of this, the reporter's notes to the old rule. And as you all know, we're in the process of updating that rule, but the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness Mr. Jackson. The alternative is she doesn't testify. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire and they can ask her anything that they think they need to ask her. So those are the parameters of that.
And so Dr. Russell did a very embarrassing voir dire. She barely made it through it to see, and she was allowed to testify. I mean, just barely. And then we had this famous hearing. So we had the same problems, strangely, in this trial with discovery and the same kind of motions to exclude their testimony because, hold on a second, because I just lost my train of thought, because the same discovery violations, same motions to exclude ARCCA, and then just exclude Richard Green because it was debunked opinions, but apparently Richard Green refused to testify, so he excluded himself. He said, I guess he didn't want to perjure himself a second time. I don't know why if you're going to perjure yourself one time or twice, if it makes a difference, if you've already done it, but okay. But here is the day we found out. So they had been presenting these ARCCA witnesses Oh, wait. Hold on. Actually, I skipped a big part of the story. So they've been presenting these ARCCA witnesses as non-biased, unpaid for, hired by another entity, which they were, but it's hard to distinguish where the federal case ends and the defense begins. They seem to be one and the same. We don't know why, when David Yannetti and Karen Reed went to the Attorney General's office, that they agreed to do this federal investigation, which they found nothing. Maybe some mean text by Proctor, but no corruption, certainly, and no planning of evidence, and no evidence that anyone else did this crime. So they've been telling the courts in motions, filings, and the jury that they were not paid for experts, not retained by us, retained by a separate entity, paid by a separate entity. And according to ARCCA, these ARCCA witnesses, they aren't paid directly by the defense. They're paid by the ARCCA company. So maybe that's how they're making a loophole and thinking they won't get charged with perjury for saying, we're telling the jury we weren't paid by the defense in this case, but they were. Everything you hear in this opening is a lie, except for the fact that he'd never seen Alan Jackson before, as far as we know. But they had spoken, they had text messaged each other. You'll find out they really scripted the ARCCA testimony. And so here is the beginning of Daniel Wolfe's testimony last year in Karen Reed's first trial. Take a listen to how Alan Jackson starts it.
So the evidence given to the court and jury in the case now, we're hearing the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
Dr. Wolfe, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCCA, A-R-C-C-A.
And what is ARCCA exactly?
So ARCCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCCA, correct?
That is correct.
What sort of contracts does ARCCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government, as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me the synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night, there's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of.
Also, after a woman has 9+ drinks and has a fight, and a psychopathic woman has a fight with her boyfriend after night of drinking and decides to run him over 24 miles an hour in reverse, we help her get out of that jam by using just pieces of the evidence, not really doing sort of a sloppy job and telling the jury that it's just not possible, by using just some of the evidence and never consulting with the Commonwealth to use the totality of the evidence.
How do drivers respond based upon the hazard they're presented with? So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolfe, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCCA?
A little over 7 years now.
What education, training, background qualifies you to perform the duties that you just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object, spatially, without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk,
anytime someone says I'm going to be honest with you, I think they're not being honest. What it comes next, I'm very skeptical of.
It's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it would probably be well over 1,000.
And how many of those 1,000, I know you don't have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize.
Right. It's the drivers strangely have more crashes at night.
Now, Your Honor.
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You had never met Miss Little.
No.
Right. At the time he was hired. He claims he doesn't know. But I always wondered if there was a background with him and Alan Jackson. But, how did he start writing emails to him, Dear Alan, so easily and so casually?
Mr. Unetti?
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained, Mr. Jackson, you can ask it differently.
Right. You can get that in a different way. You can get that lie in differently. In fact, you were retained and paid for by the defense. But I'm going to make a big song and dance for the jury, who many didn't buy this.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
I neder asked you specific questions, except in a voir dire when I didn't hand over the discovery, except when we were working out what you were going to say in a script.
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
So it goes on and on and on, and he will return to this subject later in this direct of Daniel Wolfe. So just to give you an idea, this was not a small thing. Then we have same thing after fighting to get any information. Finally, the defense, and here Hank Brennan thinks it might be the federal government he got it for because he asked at the same time, wasn't sure who gave it to him, or he thought it was the feds who gave it to him, meaning the Attorney General's office who gave him this discovery, meaning these communications between a bill of $23,925 from ARCCA that was paid by the defense. So here's Hank Brennan dropping the bomb about this discovery and how it's been a lie. And then after this, I'm going to spare you, but there's a hearing where Alessi argues that they didn't lie and that there was a pause and that they didn't communicate. Oh, it's a big misunderstanding. And it's a little bit like Clinton's deposition about Monica Lewinsky. What is when you said they hadn't get paid yet. So when he said you weren't being paid by us, they hadn't physically gotten a check yet, but they would. So Here's Hank Brennan spilling the beans in a hearing in February of this year.
Or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we.
Isn't that interesting? That the Attorney General's office is strangely protecting the defense, almost as if they, almost like erasing your text messages and talking to the defense on an encrypted app, almost like that. They're just not responsive when the Commonwealth is asking them for some material. There's a deep divide. There's what I've read about what's been reported about the relationship between the Attorney General's office and the defense is that there is a bad blood between the defense and the Attorney General's office. And that would certainly explain why when Hank Brennan asked for this discovery from the Attorney General's office they were non-responsive, i.e. they ghosted the Commonwealth.
We got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says,
I love Hank Brennan's dry sense of humor, his sarcastic comments. This fair, objective-minded witness who knows no one, who's clearly not getting paid.
So not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
Do you remember Friday? He said, well, I just wanted to inform the jury of this important thing. And then Hank Brennan asked him, but you were willing to leave out this important thing and not have the jury have a full he said that he wanted the jury, this is Daniel Wolfe for ARCCA, wanted the jury to have a full understanding. But you were and then Hank Brennan got retorted, this is my words, not his, but you were willing to leave out this information if the defense wanted, so the jury wouldn't have a full understanding. See, it's not, so the Free Karen readers would say, but he testified for this at the voir dire. He testified that these accidents happen at night. So he did tell the jury this. So he wasn't hiding it, but he was hiding it from the Commonwealth. That's the important thing, is that the Commonwealth have a full understanding of all your opinions so that they can rebut them. If the Commonwealth had withheld any discovery from the defense that could be seen or could be used by the defense as exonerating or helping her get off, and that's a very broad, it's usually really any evidence at all, they could have declared a Brady violation and she could have walked. You know, I love Alan Jackson arguing in the beginning, well, we didn't get hear about this one meeting where Jen McCabe answered one question, which we had, and we asked no questions about it. We had before her testimony. We got it late, but we didn't even ask any questions about it. Clearly, this is hugely important to this case. And for the Commonwealth not to be able to prove their case and not understand the defense's strategy is huge. And that is the dirty trick that the defense has used time and time and time again. Hide everything. Talk on encrypted apps. Everybody delete their information. And now I think that at least, I mean, I can't guess on what is on those text messages that they deleted on things that haven't come to light at all. But I would think that some of those communications on those text messages had to be about their new accident reconstruction. And hey, you know, do you really want us to write a report? Do you really want us to hand over this evidence? Because it doesn't look very good for you. The taillight shattered in a zillion pieces. We recreated John O'Keefe's arm injuries pretty much. We proved this Commonwealth's case. We showed how the crash test dummy pirouetted and would have, had he not been held on suspensions, been knocked out of his shoe or shoes the way John O'Keefe was knocked out of his shoe by Karen Reed's 6,000-pound SUV. So, yeah, really damning stuff.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before the response.
All rise, please.
So, spoiler alert, when she comes back, she's trembling. Actually, I'll show it to you. But as I'm moving forward, I want to thank Carol Holderman for the donation via Venmo. I want to welcome and thank my new Patreon members, KB, Karen Frankiewicz, and Stephanie Lamberson. Welcome. Thank you. Welcome aboard. Could his head, this is me freaking out at the time reacting to this. If you want to support the channel, links are in the description of this episode. Every episode is really supported by you. You guys make these live streams happen, and thank you so much for all your support. I appreciate it. Links in the description of this episode, as always, and every episode. Okay, so I guess I was playing it back. When she came back, it's a long break that we had here. And then she comes back and she's shaking. You're bigger. So here we go.
Back to session, may be seated, make noise, cell phone off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week.
So she's basically saying you're in big trouble, defense. Start preparing your lies. I mean, I think she should have asked them right then and there. Why not? Why do you have to prepare your defense? And so they threw a lessee up there to lie for them. And I mean, it went on forever, talking in circles and riddles and pauses and this, and we all misunderstood. And it's really the Commonwealth that's the problem. I mean, and spoiler alert, the Judge Canoni decided that it was a violation by the defense. I mean, every lawyer who watched this knew they were in massive trouble. They had been lying. They lied to the jury. They elicited perjured testimony from their witnesses. We can watch Rentschler's testimony in a minute. So that's, I'm not going to go over the entire history. I just don't have time. But I'm trying to give you a flavor of how we got here. And so it wasn't surprising to me to hear that they continued on when the Commonwealth continued to press on and ask for this discovery from ARCCA, that they deleted all of their text messages and then talked on an encrypted app that that was set to auto delete. So nobody had any communication to hand over to the Commonwealth, which is should be a violation. I mean, I'm sure ARCCA has rules about that, keeping all the information for the clients, all the client communications. As an expert witness, it's very unusual to delete your text messages or communications. And as a lawyer, you're supposed to keep everything related to your client, including your communications with your expert witnesses for, I think it's 6 to 10 years. So it's just wild. But in other happier news, we'll get to Rentschler's testimony in the first trial in a minute. But before I do, I got a shout out from Julie Grant on Court TV. Wanted to show you guys. I was watching her episode about these ARCCA witnesses, and she had two lawyers on saying that, like, oh yeah, like it should definitely continue on with these ARCCA witnesses. I don't know. I think cut her losses. I got a interesting direct message today from a listener who was saying, well, how are they proving their case that there was no collision and that he went into the house? We haven't had any testimony that John O'Keefe went into the house. Well, last time they promised in openings, I mean, what this person was saying is that Alan Jackson promised that he would prove that John O'Keefe went into the house and he was beat up and attacked by a dog, and no collision in opening statements. I've been over Alan Jackson's whole opening statement recently, but it's nothing new for the defense. In the first trial, they said they would prove that Karen Reed was framed, and all they gave the jury was mean texts and butt dials. I mean, you know, which I'm not even sure that those calls connected. A lot of them. So you're so quick. So here's Julie Grant giving this channel and me a shout out. I was watching it and I heard my name, so take a listen.
This is from, I believe his first name is Daniel Wolfe from ARCCA. Let's take a look.
Were you ever provided with a video of the defendant backing out of a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
Now, as far as from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the tail lights that you observed in this particular case?
At that speed, no.
Okay, so that was a little flashback Friday clip. Adam Lally on cross, and he was crossing him about that little, as Roberta Glass, friend of the show, calls it a love tap, when Karen Reed backs up her SUV into John O'Keefe's SUV, and Dr. Wolfe acknowledges that that wouldn't have caused the tail light to break. Joe Tamburino, tell me, is the juice worth the squeeze in calling these ARCCA experts in round 2?
I think not. I'm not sure that they're watching the testimony. They seem like busy lawyers. I'm not sure that they're watching. They were both like, yeah, definitely. She doesn't have any evidence of her. She has no one else. So that was fun, right? To hear her call out my love tap. I mean, they basically proved that she couldn't have broken her tail light with that love tap the first time, right? At 5:07. So what are they doing? What are they doing there except proving the Commonwealth's case? Funny. Also, Aiden Carney goes into trial. Hold on. Yeah, let me show you this. Maybe I'll show you this instead of, I mean, do you guys want to see Rentschler's testimony? It's kind of dry. I don't know. Would you prefer I talk about it? I don't know. I'm tempted to just show you this Aiden Carney. His trial starts tomorrow. Yeah, the Rentschler testimony. I'm kind of in the mood to show you this instead. Let me know. Maybe we can do both, but I thought this was fun. Also, hold on. What's in my bookmarks? Give me a quickie. Did I pass it up? Why can I have to hold on? Let me find it before I start fully. I know I bookmarked it. Okay, here we go. So this is Chat GPT about Aiden Carney is on trial tomorrow for witness harassment. So he's on trial at the same time as Karen Reed. So if you don't know, Aiden Carney is the blogger who pushed out Karen Reed's innocence fraud talking points in his blog Turtle Boys Sports, and on his live streams, Turtle Boy Live, and did a rolling rally where he went to the key witnesses in the case, and with everybody in their cars, visited their homes with their children there, had signs and a bullhorn calling them murderers and killers. Gretchen Voss, also the journalist, was in that rolling rally. I don't know. She's never talked to me about my songs. I don't know who just asked that. I'm sure she has, but she hasn't particularly mentioned my songs. So here is
murder case. It wasn't my hearing.
Here is Chat GP talking to Aiden Carney about his chances of beating this rap. I'm not convinced he's going to serve any prison time for any of these witness harassment cases myself. Not in Massachusetts, but take a listen. Chat GPT disagrees with me.
I live in Massachusetts. I was charged with violating a 209A order because my ex-girlfriend entered a courtroom where I was watching a hearing in a murder case. It wasn't my hearing, with her restraining order in her hand. It was a total setup. The court officers told me to leave, so I went across the street, filming myself yelling angrily about her, and stayed there until she was walking to her car. I followed her most of the way to her car, taking photos of her and her friends have a video of me following her. I also posted a blog about it the same day and included the pictures of her that I took while she was walking to her car. I believe that the brother of the murder victim conspired with my internet arch nemesis to have my ex-girlfriend show up to entrap me and make me do it. I was ordered to stay 100 yards away from her, and I was about 150 feet away from her. I want to win by arguing that I was entrapped, and also I am a blogger, famous for being charged with dozens of counts of witness intimidation against the witnesses in the murder case I was thrown out of. Will that be successful?
Thanks for laying that all out. I'll give it to you straight. Based on everything you've described, your proposed defense is almost certainly not going to be successful and is undoubtedly going to make your legal situation worse if you proceed. Let's break this down clearly and honestly. Here is a summary of your situation. You're charged with violating a 209A abuse prevention order in Massachusetts.
So just to be clear, that is a simulated voice of Aiden Carney. That is not Aiden Carney actually doing this exercise with ChatGPT. I know it's scary the way that they can recreate these voices, no?
That order required you to stay 100 yards, 300 feet, away from your ex-girlfriend. You admit that. She entered a courtroom where you were already seated, unclear if she knew you'd be there. You were told to leave by court officers, and did. You then filmed yourself yelling about her across the street, followed her partway to her car, took photos of her and her friends, posted a blog, including those photos, were approximately 150 feet away, half the minimum legal distance. You're also a well-known blogger with prior charges for witness intimidation, involving the same murder case connected to some of the people in this situation. This is why your entrapment defense will fail. Entrapment, under Massachusetts law, only applies when a government agent or someone acting under their direction induces or coerces you into committing a crime, and you were not otherwise predisposed to commit that crime. So, your ex is not a government agent. Neither is the murder victim's brother or your internet arch nemesis. Nobody forced you to follow her, take photos, or publish them. You have a documented pattern of harassing behavior toward people connected to this case. Conclusion: that's not entrapment. It's a person who already had a 209A order making their own choices in violation of that order. Judges and prosecutors will view your "they made me do it" argument as not just legally weak, but possibly delusional or dangerous. This is why this may make things worse. Here's what happens if you try to introduce this theory in court. The prosecution could use your blog, your videos, and your pattern of online behavior to show a long-standing obsession and intent to intimidate.
Yeah, I'd love to see the discovery in Aiden's case. All the online videos he's made and blogs and vicious blogs. I mean, if you have seen my video talking about how he went after Vanessa Rizziano John O'Keefe's cousin. There's a new interview with her after she said, after his first report for saying Karen Reed was framed, and he just went after her viciously. Excuse me. And David Yannetti was like cheering him on, great turtle reporting. And we know that they were communicating so much during the time that he was doing witness harassment, attacking the O'Keefe family viciously every chance he got. And he was communicating with the Karen Reed's lawyers. The way you know that Karen Reed's lawyers were part of that strategy is that they never said, stop doing it. I appreciate your support of Karen Reed, but don't attack the witnesses. Don't harass the witnesses. Don't harass John O'Keefe's family. They never said that to Aiden publicly or to any of the Free Karen Readers publicly. It's a strategy that Karen Reed and her lawyers want. Otherwise, they would publicly call off the dogs. No? To me, it's so obvious.
Your prior witness.
And there's all these phone calls at the height of the witness harassment campaign between Aiden Carney and Karen Reed's lawyers. So they were well aware and using Aiden to the fullest degree. There's also on my channel footage of David Yannetti slapping Turtle Boy's butt for a job well done as he walks into court. And there's also been leaked messages between David Yannetti and Aiden Carney that I've gone over, where he's saying, if we don't say hello to you, don't be offended in court tomorrow. We want to maintain, distance so you can look like you're an independent journalist. Aiden Carney was lying to his audience for a long time, saying he didn't communicate with Karen Reed or wasn't close with Karen Reed when he talks to her every day, according to Karen Reed. And you know how they talk? On the Signal app, on an encrypted app, with the auto delete function on. Just the way Karen Reed's team talks to the ARCCA witnesses.
Intimidation charges will likely be used to argue you're continuing that conduct. Trying to paint yourself as a victim when you publicly and knowingly violated a no-contact order could come off as manipulative or even threatening. You said you were 150 feet away. That's half the legal distance, 300 feet, you were ordered to maintain. That alone is a clear violation. Proximity plus filming plus public blogging equals serious exposure. It doesn't matter that you didn't speak to her. She was in a public place. You think she provoked you. What matters is, you got within 100 yards.
Well, I don't know. I don't know how a Massachusetts jury is going to see this. Heisenberg, thanks for the super chat GPT, popcorn. But it's also a really good explanation of the charges against him, which there's so many charges against him. It's hard to know which case, what case he's defending. So I thought this was a really easy way to explain or to illustrate what his trial is about starting tomorrow.
Followed her, filmed her, and posted about it. This isn't a case to play sovereign citizen defense attorney or win internet points. This is a criminal prosecution with real consequences, potentially jail time. Here's what you should do. Do not contact, follow, film, or write about your ex again, online or offline. Take the blog post down if it's still up. You should hope the prosecutor has not archived it, although at this point, it is likely they have it saved. Document your version of events calmly and give it to your lawyer, but do not try to argue entrapment yourself in court. If you have any mental health evaluations that might mitigate how your behavior is interpreted, your lawyer might explore that too.
Wait, do I sound like I have mental health?
Do I sound like I have mental health issues? But it's such a popular strategy for defense lawyers to say you're autistic, like Brian Koberger. Also, they tried it with Durst, Robert Durst. And it worked in Texas. He barely got any time for murdering a man and dismembering him. So this is a common tactic. I was talking about the innocence fraud, wrongful conviction movement, how when they get a guilty killer out and then they reoffend, they say they didn't reoffend. You're not to surmise that they actually did the crime the first time. Definitely don't look at the trial transcripts, whatever you do. Don't look at the appeals documents. Just believe our version of the first case. And then they say that they were traumatized. They have post-traumatic stress from being in prison, and that's what made them offend. So they love to point to mental health issues. We heard in court Marie Russell defend Karen Reed, saying that the reason that she sounded so guilty in her interviews, her multiple interviews, that are now the narrator for her own murder trial, was because she was so traumatized and in shock and grief. We've never seen shock. We've never seen grief. We've never seen remorse. We've never seen even a hint of sadness from Karen Reed. If anything, we've seen her bragging that she did it. And somebody, that's what I see. When I look at Karen Reed, I see a woman torn between wanting to brag about her murder of John O'Keefe and how powerful it makes her feel, and how she taught him a lesson by removing him from the planet for good. I mean, she just shows so much hatred towards John O'Keefe, disgustingly, and his family, and such a need to re-victimize them. I see that on one hand, and on the other hand, I see a woman who wants to get away with her murder by enacting revenge on everyone who has the knowledge of her guilt and could testify in a powerful way. I mean, there's a reason she didn't go after Carrie Roberts and she went after Jen McCabe. Because Jen McCabe, she knew, being the psychopath that she is, she summed up Jen McCabe very quickly as being a powerful witness against her, and she has been. That's why Jen McCabe was part of the conspiracy and not Carrie Roberts. She also had the advantage of being at the house that night. But Carrie Roberts certainly has never been accused of being part of even a cover-up. He's been totally left out of it. Where Brian Higgins also has a lot of testimony that's very bad for Karen Reed. Michael Proctor, Buchanan, where she gave the finger twice to this time. I know the Free Karen readers are going to say she was itching her nose, but she had nothing else in her hand, and she had 5 fingers to choose, 4 fingers and a thumb to choose from. And she chose the middle finger, really? Twice? Really?
Health issues?
Honestly, based purely on what you've described, no, not necessarily. You don't sound mentally ill. You sound like someone who is angry, controlling, and has a persecution complex. I am not in a position to diagnose you, and these traits do not always equate to a mental health issue. But here's the thing. In court, the way your actions appear to others, especially to a judge or jury, can matter just as much as your intent, and the combination of defying a restraining order.
Tanya, Vincent, is it Vincent? Is it Vincent or Vincent? Let me know. Vincent says, will Hank seek conspiracy charges after the trial? I don't know. I'm more curious what's going to happen to her lawyers, aren't you guys? I am. Shannon, thanks so much. Very generous of you. Thanks so much for the super sticker. I appreciate it.
Filming yourself yelling, posting about it online the same day, being tied to ongoing witness intimidation cases, insisting you were entrapped by a conspiracy involving a murder victim's family and your internet enemies, can easily be framed by prosecutors or judges as unstable, obsessive, or dangerous, especially if it looks like you're unable or unwilling to stop fixating on the people involved. That doesn't mean you actually have a diagnosable condition, but in court, perception can shape outcomes, particularly when the case is about violating a protective order, which already centers around safety and control.
Oh, and by the way, my trial starts in 2 days.
Thanks for the heads up. And to be brutally honest, you're in the red zone now. If your trial starts in 2 days and you're still thinking about arguing conspiracy, entrapment, and posting about witnesses, this is your last real chance to stop that train before it crashes. 2. Do not try to argue. Entrapment. Even a decent lawyer probably won't let you argue this in open court. And for good reason. It won't be successful. It makes you look unstable or paranoid. It opens the door to all your past online harassment and witness intimidation charges. This is not a Reddit thread. It's a courtroom. Juries care about rules and self-control. The more you look like you're trying to justify bad behavior with conspiracies and online beefs, the more guilty you'll look.
Oh, and also, I have picked up 2 more witness intimidation indictments last month. Does that matter?
Okay, you've now got a pending trial in 2 days for violating a 209A restraining order, prior witness intimidation charges, and 2 more indictments for witness intimidation just last month. Let's be perfectly clear. You are not walking into trial in a strong position. You are walking into court with flashing red lights and a neon sign that says, high risk, persistent offender.
Right. I wonder how many of the other witness harassment charges they can talk about. I wonder if they're going to show, if the prosecutors are going to show a pattern here of past bad behavior. What do you guys think?
From the prosecution's point of view, your story now looks like this. You've repeatedly harassed people involved in a murder case. You've defied protective orders. You've published content online about protected parties, even after being charged. You've been indicted, not just charged, for multiple counts of witness intimidation, most recently just weeks ago. You're showing a clear, escalating pattern of conduct that violates court orders, intimidates people connected to criminal proceedings, shows you won't stop, even under threat of prosecution. To a DA or a judge, you now look like someone who is either uncontrollable or choosing not to care about consequences. That is the worst position you can be in. The prosecution will absolutely try to introduce some of your past charges under prior bad acts, Massachusetts Rule 404B, if they can show a pattern of harassment or motive. Even if your lawyer blocks that, the judge already knows your background. If you're convicted, your sentencing is going to be harsh because you're not a first-time offender. The court may view you as a danger to witnesses, or the public probation is unlikely to be offered without strong mitigating factors.
But, I mean, this is the first one. I would doubt he would get jail time for this. Someone just asked me about jail time. It's not in Massachusetts. I know he's had other charges in other courts, but I don't know. I don't know what's coming into evidence. I'm going to be trying to keep one eye on the Aiden Carney trial, and as we finish up the Karen Reed trial, we have Rentschler tomorrow. So there's that. We also have La Posada, who is the disgraced Rhode Island medical examiner. She's coming up, and she may hit it out of the park. She can be very convincing. She's a consummate liar and a very practiced expert witness for the defense. I mean, I don't know how the defense is going to buy anything other than hit by a car, but maybe she has some other cause of death that she's going to testify to. I have no idea what her opinion is. Hank Brennan is an excellent cross-examiner, but so is Adam Lally. So, we got a hung jury. Certainly, there's a reporter who's commenting on the jury and says one juror seems to really dislike Hank Brennan. I've heard other reports from Free Karen Reed people that have been in the court that they're rolling their eyes when Hank Brennan objects, or some of them are. So, I don't know. We may already have Free Karen Readers on the jury, and we may be going towards another hung jury. We don't know.
This is serious. You are playing with your liberty now. You don't need to win the internet. You need to not get remanded to jail next week. If you're ready to stop digging and start fighting smart, I'll help you however I can. but you've got 2 days, so time is almost up.
But do you really think I am going to be convicted? I'm a famous blogger with First Amendment rights.
I hear you, and I'm going to level with you with respect and honesty. Yes, you absolutely can be convicted, and your First Amendment rights will not protect you from that at all in this situation. Let's unpack that clearly. The First Amendment is not a shield for harassment or witness intimidation. You do have the right to free speech, but that right stops the moment your speech violates a court order, like a 209A restraining order, harasses, threatens, or intimidates someone involved in a legal proceeding, interferes with the administration of justice. Posting photos of your ex while following her after being ordered to stay away is not protected speech. Calling a murder victim's mother a cunt at court appearances is not protected speech. Blogging about witnesses, especially while facing multiple indictments for intimidating them, is not protected speech. Courts do not care that you're famous. They care that you're a repeat defendant. Being a famous blogger does not grant you immunity, make you more sympathetic, give you extra leeway to violate protective orders. If anything, it makes you a bigger liability in the court's eyes because your actions reach a large audience, are well documented, are persistent, and public judges and prosecutors will argue that you're using your platform to target people, escalate hostility, and intimidate witnesses under the guise of free speech. Let's be clear. You've already admitted to conduct that clearly violates the 209A order. You're on the hook for multiple active indictments for witness intimidation. You have public blog posts and videos that the prosecution can use against you. You're going to trial in 2 days. This is not a political or speech case. This is about criminal behavior while under court orders. Unless you present a credible strategic defense and stop digging the hole with more online content, you're walking straight into a conviction. If you take this seriously right now, your lawyer might be able to negotiate something. You might get a continuance without a finding, CWF.
And that's something he's been hinting at, is that they might want to make some kind of deal that if he turns on Karen Reed and her lawyers and tells everything, that they may give him some kind of deal and he may take it. I don't know. That rumor is certainly going around. I mean, he said on his show that they offer him a deal, he'll do what's best for himself. But it would have to involve no prison time. Any prison time that he gets, I think he's going to demand that he be in isolation anyway. I mean, just Keith Raniere was certainly in the special offenders unit.
If it's your first 209A violation and you're lucky, you might be able to frame your conduct as reckless and emotional, not malicious. But that window closes fast, and I'm a blogger with First Amendment rights won't save you. It could actually hurt you if it sounds like you think you're above the law.
You're getting oddly specific. Who do you think I am?
Based on the details you've shared, the 209A restraining order, the photos and blog posts, the history of being thrown out of a murder case, the accusations of witness intimidation, and the references to being a famous blogger, it strongly sounds like you're describing Aiden Carney, also known as Turtle Boy. If that's not you, then you're describing someone with an eerily similar legal situation. Either way, here's what matters. The courts do not care how many followers you have. The First Amendment won't protect conduct that violates court orders or intimidates witnesses. And every single thing you say or post, right now, today, is fuel that prosecutors can and will use in court. Whether you're a Turtle Boy or someone in his orbit, you're on the edge of real consequences. If you want help crafting a defense narrative, distancing yourself from escalating charges, or salvaging your future, I'll help you. But the next move needs to be legal, strategic, and serious. Let me know how you want to play it.
I think I'm just going to go do some drugs, jerk off on my furniture, and then do a crazy live stream tomorrow, projecting myself as a winner.
Look, I know you're angry, probably feeling cornered, and trying to hang on to a sense of control or...
Yeah, LOL. I mean, come on. It's too accurate, but I don't know. I think he's gotten a real education in innocence fraud. And he may weasel his way out of these, everything. I'm not convinced he's going to do any prison time. I'm just not.
Or identity through bravado or defiance. But what you just said, that's how people implode right before they lose everything. You are staring down serious criminal charges. You have a trial in less than 48 hours. This is not just a spectacle anymore. This is your real life. And if you keep acting like this is all content, the system will absolutely crush you. No one is going to care that you called yourself a winner on a live stream when you're sitting behind bars. That's not power. That's denial. Talk about this only to your lawyer. Shut up online. Regroup. I'm still here if you want to pull back from the cliff, but you've got to decide what you want more, attention or freedom, because you're not going to get both.
Okay, that's it. That's some good advice, AI. Some good advice. Shut up. I mean, you know, I think if we learn anything from the Karen Reed trial, it's silence is golden if you're a defense witness. Here's a little bit. I'll show you a little bit of what Rentschler's like on the stand. Here's his testimony from last trial. I've sped it up slightly. See if we can move forward. This is Karen Reed, not at a sidebar.
You are unmuted. Can we go a little past one to?
It's a blast from the past. Like, definitely, you know, it's not this trial. She's not up with the lawyers at the sidebar.
To keep going with this, if that's okay. Everybody's nodding. All right, thank you.
Step right up and step on me. Stand and face the clerk. Please also the evidence of the court and jury in the case and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I inquire?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record?
Certainly. Andrew Rentschler, Rentschler.
And what do you do for a living, sir?
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCCA LLC.
How long have you been in that position as working for ARCCA?
I've been with ARCCA for about 16 and a half years now.
And you indicated that you're the director of biomechanics and human factors. Is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say crash injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body. I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have again, a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and professional classes with respect to biomechanics as well as accident reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's.
Yeah, really good question. I mean, why are they working so hard to prove a collision that never happened? right? It's bizarre. I mean, they haven't really presented any evidence that anything else happened. I mean, I guess, I don't know what the free Karen readers, I mean, they're giving me no frostbite. That's what they're giving me.
It's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break. We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or an irreversible disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between
So he goes on, that's just a little flavor of him. I mean, I won't bore you. It's with the testimony. It just gives you a little flavor of him, what he might be like tomorrow. I don't know what he's going to say about these tests tomorrow. He does say in that testimony that your arm weighs exactly what or close. I don't know if it's exact or approximately what your head weighs. Just a little trivia there. Just a little trivia. So we'll see how he does on direct. If there's anything more that he's going to show that might be helpful for Karen Reed. Does it feel different than the first trial, B-Rabbit? I feel like the press is helping out Karen Reed, even when we see like an overwhelmingly bad day for her, just like it was last year. It all sort of just gets negated by the way the press reports on it. Hopefully the jury isn't doing what they did last time, which was talk amongst themselves and look like some of them were looking at outside or bringing in outside material in. B-Rabbit, yeah, I don't know. I'm hoping she will get convicted. Maestro's convinced she will. You agree, Curly? It's very odd feeling. It's like, what did I just watch? Are my biases getting in? I don't see them making any great strides. I don't feel like I am that biased. When they did that, when Robert Alessi did that cross-examination about the not updated resume on LinkedIn, I thought this isn't good for the Commonwealth. It wasn't good. I thought he was a good witness, but how they're going to weigh that, if they negate his testimony, that's not great for the Commonwealth. I feel like I'm being as fair as I can be, but almost every day, it's just another terrible day for Karen Reed. I don't know. That's how I see it. But then I go online and there's some spin. I mean, like if you look up Karen Reed just on YouTube, I'll tell you what comes up. Like it is about the cop, the female cop who testified. Did she, is she hiding something? Is she part of a thin blue line? Proof taillight was smashed. Kelly Deaver, did she lie? Body language analysis. Did Kelly Deaver change her story? Court TV about meeting with the police commissioner. Here is lawyer they constantly push his videos on my feed. ARCCA with some serious testing, but will Brennan break it? Jen McCabe, her hyperthermia, Google lies exposed. I mean, so yeah, odd. It's an odd feeling. I mean, when that headline from Kelly Deaver's testimony should have been that the defense were pressuring her to lie under oath, it was just like, oh, she had an attitude on the stand, strangely for no reason. Not that then paragraph 12 or whatever, 10 minutes into the program, if it's a video, you find out that the defense, yeah, I don't want to get everyone depressed. We may be headed for, I hope I'm wrong. I'm just, a little shy of saying that this is a slam dunk it feels like a slam dunk every day that I watch it, but I don't know. I don't know who's on the jury, and I don't know if the Innocence Fraud campaign has come into the deliberations or will come into the deliberations, or who the jurors are. And yeah, that's my essential thoughts on it. Did someone else ask me a question? Just Me says, I am preparing myself for a negative outcome in spite of the fact that I will be disappointed if she gets acquitted. Yeah, she still hasn't, maybe like OJ, she still has the civil case, which I was planning to go over today, but it just seemed like everybody was still interested in talking about ARCCA. Civil case she still has to face. It may be like OJ. She may live a life but of celebrity, but OJ also didn't have the real press's support, though. So it may be different. She may be called, if she gets acquitted, she may be called exonerated, even if she loses civilly. I mean, civilly, you just have to see, this is how innocence fraud works, is they sue in our civil courts where the bar of evidence is much lower. So it doesn't mean that the evidence is weaker. I just saw someone misinterpreting this the other day. Maestro knows what I'm talking about, saying, oh, you can bring in weaker evidence. No, it just means that you have to meet a lower standard. So every piece of evidence doesn't have to meet a standard of beyond a reasonable doubt. It's the totality of the evidence. That's the standard in criminal trials. In civil trials, it just has to be 51% more likely than not that something happened. And that's how they get all these multi-million dollar payouts from guilty people. They present a totally different picture of the case. Nobody is there from the trial that convicted them. And they either overstress the importance of DNA evidence or some other trick, and they get these multi-million dollar payouts. And that's why we have this, this innocence movement is making lawyers rich all over the country. Not that, we don't have real wrongful convictions. They do happen, just not at this rate that the wrongful conviction movement is purporting. It's absurd. I mean, they're saying that basically every day, tons of people are getting wrongfully convicted, and that's just not the case. All right. I will be back tomorrow. I hope you'll watch the trial with me. Please hit the like button, subscribe to the channel, share this episode, support the stream. Links are always in the description of this episode. You can buy me a coffee, send me a Venmo. Great way to support the channel. Patreon, great way to support the channel. Links all in the description of this video. Thanks so much for watching this with me. And I'll see you tomorrow morning at 8:40. We can watch the day 29 of Karen Read's trial together. Have a great night, everyone.